Good afternoon, everyone, and thank you for joining the last CLE of the 2025 year for DVAP. As you know, DVAP is a joint pro bono project between the Dallas Bar Association and Legal Aid of Northwest Texas. Our purpose is to provide pro bono legal services to low-income Dallas County residents, and we do this through the generous support of our volunteer attorneys who not only staff our clinics, but also sign up to take a case. So, as part of today's presentation, we have Melinda Hartnett. Melinda is a partner at the Hartnett Law Firm, where she practices estate, trust, and guardianship litigation with her four brothers, one niece, and two nephews. She is a Dallas native. She attended Hamilton College in New York and then Fordham Law School in New York City and lived in New York State for 13 years before returning to Dallas. She has five children, which means she will work forever. I am sorry. So without further ado, please join me in welcoming Melinda Hartnett, who will do the majority of our today's presentation.
Thank you. Hi, everybody. Thanks for joining us today. Hopefully this presentation is new for a lot of you. I've been doing it a number of years. So if it's not new, you may see some information videos you've seen before, but hopefully it's new to you. So it'll be fresh. I do throw in some videos or interesting things from cases we've had just to kind of spice it up and so you don't have to hear me the whole time. They're not exactly pertinent on how to probate a will, might be pertinent if you're an estate planner or doing anything like that. And hopefully they'll be entertaining at the least and give you a little bit of flavor for what we do here. So my goal today is to help you in learning the basics about how to probate a will, which is should be a fairly simple process. It's not always. And especially right when you think it's simple is when you'll run into some kind of little problem. But a great way to get in front of the judges, a great way to help DVAP when they need people to probate wills for their clients, and just to get some experience in the courtroom. So we are going to cover your first look at the will, information needed to probate a will, look at a simple probate of a self-proved will, a simple probate of a non-self-proved will, issues to look for, what happens after the will is probated, and some tips I have for you. So here's something we deal with ours, a little comedy there where your family, someone dies, and even if they got along really well during life, doesn't always happen that way after life. A lot of times it's based on years of family dynamics, but not always. All right, your first look at the will. Client comes in and says, I need to probate a will. My mom died, my dad died, whatever. So I first look at the first page. It's always basics. Look at the signature and date. Do you find out when the person passed away? How close in time is the will execution? And does the signature look questionable to you? I'm not assuming people are taking advantage of people all the time, but I'm always going to look at that first. Look at the witnesses in the notary. Do you have two witnesses? Was it notarized? Sometimes there's a one-step signing, so you might have the witnesses signed twice, or you might have it all done on one page. I'll then look at the specific and residuary bequest to see if there's anything odd or that looks like perhaps it doesn't deal with all assets of an estate, something like that. Just a quick glance. I'll look at the executor provision. Was somebody appointed? Were they named as an independent executor with the proper language? And is that person alive or is there a successor? And then I'll look at the rest of the will quickly. This is, again, a first glance. I'll read through it more closely if I've agreed to probate the will or once I'm moving forward with that. Does it dispose of all property? Like I said, when you look at the specific and residuary, and we'll have a will, I'll show you a will, where you can run into some problems with that. And then you're dealing with partial intestacy and likely need an heirship as well. Are you sure it's an original will? This is getting harder to tell with Xerox copying the way it is now and printing. It can be difficult. There used to be a spit test. You could lick your finger, and if it's smeared, it was an original. That doesn't really work anymore. Probate Court 2, I put on here, this is sort of an old note, but this is from Judge Monroe. For those of you who knew him, he was the associate judge who retired not all that long, but is showing up in our courts quite a bit since then. He had a high-powered printer's loop and could look to verify whether it was an original versus a copy. And I can tell you, one of ours, it ends up was a copy, and we had no idea. We would not have known but for that. So be aware that that can be an issue, and you want to look as closely as possible and maybe discuss it with your client. And then you want to look and see if there's a self-proving affidavit, because if it's not a self-proving affidavit, you're going to need an additional witness at the will probate. Can get by it. It's fine to get by. It's fine to have that kind of will, but you are going to need more witnesses and more proofs. So here's a will that we had for a well-known Texas Longhorn player who was a wealthy guy later in life, and this was his will. And obviously, it's a holographic will, all in his handwriting. There wasn't a dispute about that. There was a dispute about what his actual will was. So you can see one page, you can see it says not will, and he signs it, scratched out through things, another not. The other side of the will had this. This is not my will. I leave everything to my wife, but then there's arrows with a new will, other arrows. This will actually got probated quickly without notice to family members. And we believe the judge didn't know there were kids from a prior marriage and probably would have questioned it more had he known that. And we did contest it and went forward on that basis. So hopefully your will won't look like that. Here's a more basic will, what you would be getting on a simple probate, without any need for big trusts or any, large estate tax planning, that kind of thing, which these days with the tax exemption, you can have your wills can be a little bit simpler because there's so much in the tax exemption. But you can see here payment of debts, disposition of the residue, so no specific bequests. There's an executrix as independent. They have the next paragraph about not being required to give a bond, no action be had in the probate court, etc. And then you get to the end, I can see that it was signed by the testator. I can see there's two witnesses. And then that page there on the right is the self-proving affidavit, signed by the testator, two witnesses, and also notarized. So overall, looks like it'd be pretty simple. And formatting wise, it looks like it checks the boxes. All right, so this is the first of our videos, and this is a case that we did. We were actually involved in the guardianship over this individual, and then he succeeded in hiring a private investigator who helps get him out of the guardianship, and then, of course, got a will leaving it all to him, the private investigator, and his little teammate in taking advantage of this man. And so they went in, the person who's speaking is the private investigator who is very helpful and a very dear friend of the testator. And this was in the hospital to get a will done. And you'll see just how it went.
Okay, Buford, you just finished signing your will, right? Okay. And we have witnesses here as well. Sharia's here again to notarize it, right? And we have the two witnesses who are witnessing your signature. Okay. And you're aware of what the will says. Yeah. And the fact that you're making bequests to several different people. There's a large bequest to either a foundation or a trust fund or something that will then distribute money according to your wishes. You've left things to me and to Irene, and you've left things to about 5 or 6 other people specifically named in your will, right? Okay. Now, you signed the will. Were you coerced into making it? Did somebody beat you or force you to sign it?
No.
I noticed that you have in there a specific thing about your cousins.
Yes.
Okay, you've left them out.
On purpose.
Why?
Because they didn't want me to have a country to live in. That's the best reason I can think of.
What do you mean?
Well, they told the judge that they agree with everything you did. Took everything I had away from me for no reason that I can see.
So you intentionally left them out of your will?
You bet.
Okay. You can add whatever you want to say. You're fine. That it?
Well, that's it.
Okay. All right. Okay, today is August the, what'd you say? 13th? 13th. Okay, 2015. Okay, thanks, Buford.
So hopefully you can see some red flags through that video. We generally, in our cases, love a video. Oftentimes it'll help us in our case rather than prove somebody had capacity. And we were successful in overturning this will as well as several other wills he did, leaving it to the individual speaking and someone else. He also, the PI made misstatements about the estate. He was not leaving a large amount to a foundation. It was going to the PI and his fellow employee. All right, so information that you need for your application once you have the will and you've decided that you're going to represent the person in probating the will. You need the testator's date of death, their date of birth, the decedent's residence, the applicant's residence, and the social security number and driver's license number, if you can get it, the last three numbers for both the decedent and the applicant. That goes into your application. A lot of times, if it's an elderly person, they might not have a driver's license or even an ID number, and that's fine. You're not going to be kept from probating a will because of that. You want to look at the executor qualifications, which I'm going to discuss in the next slide, and make sure that the named executor is qualified. Another question is, does the executor live in Texas? If not, you're going to need to prepare a designation of resident agent and have that on file before you can prove up your will. It's a decent idea to know who the heirs at law are. It's not required. You don't give notice before a will is probated. You don't have to give notice to anybody except for the posted notice. But if you see a will and there's something odd about it, you might want to know, is everybody on board before you jump in and find yourself in some litigation. If it's a small estate, there's not enough to fight about. It's less likely, but it is a possibility. So if you see it's going all to nieces and nephews, you might say, well, did this testator have any kids? Did the testator have a spouse? Things like that, just to know what you're dealing with. Course looked at it and determined whether it's self-proved. Is there power of a sale? Does the executor have a right to sell property? So for example, if a house is left to three children, it may be that those three children don't want to get the house, have it deeded to the three of them. They'd rather have the executor sell it and distribute the funds. So if that's not included in the will, you're going to need additional information in the application to grant the executor power of sale. Death certificate. I don't know if this is now required for all courts. It is in Dallas County. I don't know about other courts in the state and other counties, but the death certificate more often now is being required, generally redacted, and it varies whether you email it to the court or you e-file it. And it may be that it works either way for courts. I know in the Dallas County courts, generally you can e-file it or email it. And even if you e-file it, it doesn't go on the portal, just like inventories and accountings, it doesn't, and doctor's letters and guardianship. You'll see it with the date, see the title of it, that there's a death certificate, but it's not something anybody can access. All right, here are your executor qualifications. Are they over the age of 18? They ever been declared of unsound mind? Are they a resident of Texas, or can they appoint a resident agent? They have no felonies. This is no longer an absolute bar under certain circumstances. They'll still be reluctant, and it may depend on the felony, but it used to be an absolute bar, and now it's not necessarily an absolute bar. No misdemeanors involving moral turpitude, no bankruptcies. Again, bankruptcies 20 years ago, there's some story behind it. It may not be an absolute bar, showing the person has, business experience now and it has done well for 20 years. It just kind of depends on the court. But you really want to talk about these things with your client or whomever the executor is, so you get the story. You don't want to be in court, and this happens. It happens to the best of us. Despite talking to the person and asking all these questions before, you get in front of the judge and say, you've never been convicted of a felony. Isn't that correct? And they say, well, actually, and then you have to deal with that. Again, maybe you'll get through it, but maybe not. It might be an issue. Here's the self-proving affidavit that it can be attached to a will, and it has to be in substantial compliance with this form. It has basically the questions that you would ask and approve of, but it's asked at the time or made a statement at the time that the will is signed. And if you have this document, then the proofs required to probate your will are there's only one, and the requirements are less stringent. I'm going to get there in just a minute about what the actual proofs look like. All right, so here's your documents for a simple probate for a self-proven will. And I say simple, sometimes they appear simple and you miss something. I've had it happen, but let's assume it's going to be clean. You need one proof of death. This can be an interested witness. It can be your executor. It can be a beneficiary. It can be just about anybody who can testify to the facts needed in the proof, which we'll get to. You need an oath for the executor. The statute says this can be a declaration rather than an oath. So you may know that there was a statute passed several years now that says anytime there's an oath, you can actually make a declaration and it doesn't have to be notarized. Our courts don't love declarations. I tend to use them a good amount because I think the statute allows it, so I should be able to use it. But you might be rejected. So some attorneys just say, no, I'm just going to go with the notary. Some say, well, I'll give it a try, and if I need to redo it, I can do it with a notary after the fact. For me, it's sort of, well, how easy is it for my client? If they work in an office where there's a notary, or they go to the bank and there's a notary that'll do it for free, great. Go the notary route. Otherwise, I try a declaration myself. You need your order probating a will drafted. Court 1 and Court 2 have additional proofs, and it may be that Court 3 also does. Things can kind of change, and you got to keep an eye on the website with what they're requiring. The death certificate that needs to be emailed or e-filed, as I said, and you can look on the court's websites and it may tell you how they want it handled. I believe Court 1 and Court 2 currently say emailed or e-filed. I believe Court 3 says emailed, but sometimes we've e-filed it, and that has been fine. You need all of these documents e-filed before you can request a hearing to probate your will. So they're not going to give you dates if you don't have each of these on file. I think this is partly because people would put it off and then get to the day before the hearing and say, oh, I didn't do my documents. I need to cancel, or show up at the hearing and not have the documents they need. And so they were having cancellation of hearings. So now you need to get these e-filed. If you need to amend a document because you realize you did something wrong or your witness changes, that's not a problem. You just need to get one on file at that time. Excuse me. If you're going to be in front of an associate judge, you need a waiver of de novo hearing. This is a standard form that gets filed. And you need a notice of virtual proceeding if you're going to do the hearing by Zoom. Again, this is a standard form now, and has to be filed so that the world has noticed that there's a virtual hearing. You know, at the courthouse, anybody can show up for your hearing. So this is a way of making sure people can show up. Okay, here's your proof of death and other facts for a simple prove up. And when I go to the courthouse, when I get called, the judge calls you, go up, they swear in your witness usually, you call the witness, and then I go down these questions with yes, no answers, generally yes. So I would say, state your name. They state your name and say, John Smith was your father, for example. Yes. John Smith died on September 1st, 2019 in Dallas County, Texas at the age of 80 years. Is that correct? Yes. And 4 years have not passed since his death. Is that correct? Yes. Mr. Smith was domiciled and had a fixed place of residence in this county at the time of death. Is that correct? Yes. And so on. Let's go on to number 3, actually. The document dated December 1, 2010 that I'm showing you purports to be decedent's will, which was never revoked so far as you know. Is that correct? Yes. The reason I'm going to point that one out is for a virtual hearing, the judge will generally pull up the will on the screen. You might want to be prepared in case you need to, if there's a technical problem, and you could, but I've always had a judge be able to pull it up and usually put it up before I even get to that number. If you're at the courthouse, often the judge will hand you the file with the will, kind of, the page is folded over so you can see it, and you just flip through it and show the signature and that kind of thing so that they can see it. So I go through those questions just like that, direct leading questions. So it's very simple if it's a simple probate. And then it can be signed off on by the judge. If you are doing a virtual hearing, every court's a little bit different. And I assume every court in the state is different, but even our Dallas courts are different. Sometimes a judge will say, shift your camera so I can see you sign, and you hold up the signature for the judge. And then afterwards, those get emailed to the judge. Sometimes you need to have a notary notarize it afterwards. There are some courts that have you sign it beforehand and send it to the court. So it just kind of depends on the court. I recommend looking at the website. And you could call the court if you want. And then also, if it's a virtual hearing, sometimes the courts will send you, when they confirm your hearing date, will send you information in that email saying, here's what you need to do with your documents. And then we have the proof addendum qualifications in court 1 and 2. I don't think that the court 3 needs these right now, but again, I check their website or check with the court when you have this. And these are statements by the executor. Basically, the qualification statements that I showed you before, they're now signing in front of the judge. Okay, here's another case we had, and with the last case, the Scott case and the Ash case, it's just interesting that you have witnesses, and the point of a witness, part of the point of the witness is to attest to the testator's capacity and what they're doing. But these cases show you that just because you have witnesses, it doesn't mean that the will is okay. We overturned this will as well as several other wills by this person. And what's interesting and to note, if you draft wills, is the way the attorney's asking questions. Can you really tell that this testator, the person being videoed, has capacity based on the questions asked?
Page 1 in the last paragraph of your will, it reads as follows. I make no provision in this will for said children, those being your 5 children, other than a contingent interest in my personal property, since adequate provisions have been made for each of them by my ancestors. Thus, the purpose of the will is to provide for my said wife, Sarah Patricia Ash. Is that your decision, and that's your decision?
Right. Right.
You're very comfortable with that?
Right, definitely.
And are you very comfortable with the fact that your children have been provided for by your parents and by your grandparents previously?
Mm-hmm.
You're very comfortable with that?
Yep.
Okay.
So hopefully you can get an idea that and see that he's not actually saying anything about what he wants and what he thinks and the reasoning behind it. The lawyer is telling him what it says, and he's just agreeing. I'll say that the primary beneficiary under that, his wife, I believe it was his 5th wife, although they were married a long time, was there in the room with them, which is helpful. Okay, so documents that for a simple probate of a non-self-proven will are a little bit different. You need an extra proof. So you have your proof of death as above, and that can be still the interested witness like it was above. But you also need a proof by a subscribing witness or other witnesses, and those have to be independent. This is because you don't have the self-proving affidavit that kind of testified to these statements you would have otherwise. You still need an oath for your executor. You need your order probating the will. You need the death certificate, emailed or e-filed, depending on the court. You need all of these documents before you can even request a hearing from the court. You need your de novo waiver for an associate judge. And you need your notice of virtual proceeding if it's by Zoom. So here's an example of a proof by a subscribing witness. And a lot of the information is what would be in the self-proving affidavit. So they're saying they saw him sign it. He published it, declared it to the other witness and me that it was his will. The testimony about the witnesses being over 14 and that the decedent was of a sound mind. So I would go through that in the same way as with the other proof of death and say, on whatever the date of the will is, you were present and you saw the testator sign the document that I'm showing to you, correct? Yes. This document purports to be decedent's will, correct? Yes. Decedent published and declared to the other witness and to you that this document was decedent's will, correct? So I go through it that way. If you don't have a subscribing witness, they're out of state, they're deceased, you just can't find them, they're not communicating, you can have someone testify about the decedent's handwriting and signature. They do need to be familiar with that, and you want to have a little, I like to have a little information. So there's the statement here that I would ask, were you personally acquainted with the decedent? Yes. And you're well acquainted with his handwriting and signature? Yes. I might say, what is your relationship to the decedent? Or how were you acquainted with his handwriting and signature? If it's a sister or something like that, it's pretty easy, and the judge will have a little more confidence in their testimony, in my opinion. So I go through these same questions the same way. Okay, the Cleo case. We're gonna dive into this one.
That whole big bunch of stuff. And we decided that, it would go into a residual trust after you make all these other gifts to like MD Anderson, Texas Christian University, Scottish Rite Hospital, the University Hospital Foundation in Oklahoma. Okay. Okay. Now, it says in here, let me see if this is okay with you. It says fees and bonds, that there will be some fees for managing this estate. Is that okay? Right. Okay, like the bank will charge or something like that? Okay. Now, it says here that on the 30th day, says Cleo Nathan House. Yeah, right. And you need to make an X right down, not up there, right here, right, put your pencil right for my name. And make one of those big X's there. I'll make an X. That's Cleo, C-L, can you get me an L? E, O. Okay, that's pretty good. Wanna try that Hamilton? Yeah. Try Hamilton, H, H, A, you remember A kind of looks like that, okay. M, H-A-M-I-L. Can you do an O-N on that now? O-N, okay, that's fine. That's good.
Shake my head every time I see that one. I know it's old, but it's really incredible and always worth sharing. You can see that poor woman. It's 9 o'clock at night. She's exhausted, and the beneficiary's just talking to her like she's actually explaining this will, and it all makes sense. But anyway, sad. Another option for probating a will is immuniment of title. I'm going to explain a little bit of it, and then I'll tell you what some lawyers think about it. Immuniment of title, when you don't necessarily need an executor appointed. So you may have one named in a will, but just given the property that's there, maybe it's all going to one beneficiary, you can use the will as basically a transfer of title. So it's probated as immuniment of title. You file it in deed records where in any county where there's real property. If it's in the county where it's probated, you don't have to file it. So if you probate the will in Dallas County, you don't need to file it in Dallas County deed records. But if there's some property in Harris County, you would file it there. It works to transfer the property to the beneficiary. So there's not an executor signing a deed, there's not an executor going and getting control of bank accounts. The beneficiary now inherits it. All right, and you can only do it where there's no debts, because you're not going to have somebody, a creditor cannot make a claim against somebody. They could go get the beneficiary, but really, normally you would go to an executor who would deal with the claim process. You need a Medicaid estate recovery program release. This is saying that they haven't been on Medicaid, and so there's no claim. If somebody's been on Medicaid, Medicaid may want to come back now that they've passed and make a claim against the estate for funds. Generally, we get MERP releases when we've had them. So it's a simple form you fill out, you send it to the MERP, and they will send back whether they're going to release their claim or not. In court 2, they will appoint an ad litem if it's beyond 4 years. And some courts also require you to sign an affidavit of no debts now. You don't just make the statement in the application, you actually have to swear to it. In some courts in other counties, they've required the named executor to waive, consent, or decline. It's always a little surprising to me because I just feel like a third party shouldn't have a right to come in and say, no, I want to be involved when they're not really needed. I don't know if that's because there's a protection about the no debts and they want somebody else to say that, or just want to be sure they have notice of the proceeding. But I feel like somebody could cause a lot of problems by just saying, no, I'm insisting on coming and getting control and having to jump through all these hoops. So some attorneys don't like muniments of title. You can run into some difficulty. For example, if it's a large estate, say there's $1 million and the will says I leave the $1 million to my 3 children. Then you take it to the bank, it's probate as muniment title, and they look at the will and say, well, it's left to my 3 children. How do I know who the 3 children are? I don't know who they are. That can run into a problem. Whereas if you have an executor, they go to the bank, grab the $1 million, and then they know who the children are and can distribute it. So there are cases where muniment of title, even when there's no debt and no business to run or anything like that, when it's not a good idea. DVAP cases, I've often felt like that was a decent option, was a muniment of title if I couldn't just do an affidavit of heirship. And other cases where it's very clear, like I said, a single beneficiary. Even if the beneficiary is the executor, there's really no need for that because there are additional requirements when you probate a will after the probate, which we'll get to, that aren't required for a muniment of title. So I personally like them. I had an issue one time where it was a large account and it was going to the children. I believe the children were defined in the will, but the bank was a little uncomfortable, primarily because of the amount of money involved. It just took a little pushing and my involvement, but we got through. We didn't need to go back and get an administration. Here's the MERP waiver that you send. You fill out this information and send it to MERP. You can fax or mail. It says at the bottom. I think they have an email address now also. And then they'll send it back to you saying whether they're going to have a claim or not. Here's the affidavit of no debts and no dissolution of marriage. This is additional proof required by some courts, and you can incorporate it into the proof of the qualifications. All right, some additional issues to look for in your will. As I said, if it's not an original, again, this doesn't kill your chances of probating the will. You can probate a copy of a will. In the estates code, it's called a will not produced in court. And it's interesting as you read it. I expect some of these statutes will change because of our Xeroxing, because we have signed copies that look like originals. Some of the provisions don't really make sense. But that's what it's called, a will not produced in court. You need to plead additional facts on revocation. If you don't have an original, the presumption is that it was revoked. So you need a statement of why you couldn't find it or who last had possession. You have to give notice to all heirs at law in a probate for a copy of a will. The heirs need to know because say you knock that will out and there's no other will, then the heirs at law would inherit. So they need to have notice to come in and say, no, we know that will was revoked. So it's required to give notice to all heirs at law. In court 2, at least, an attorney ad litem will be appointed. It's almost like you're having a mini heirship within your probate. Because basically, it says you need to give notice to all heirs at law. Well, who's to say who the heirs at law are? What if the application leaves out an heir? So an attorney ad litem is there to look into whether the heirs were listed correctly, and if not, to address that. And assuming they are, then the applicant is given notice, you're good to go forward. You don't get a judgment declaring who the heirs are, but the proof is kind of similar. This is a new change this year. Previously in Dallas County, at least, not all counties, I know this wasn't true in at least one other county, a copy of a self-proving affidavit was not valid. It was not considered a self-proving will. New statute 256.156C of the Texas Estates Code says a copy of a will that cannot be produced in court, that's the language, that includes a copy of a self-proving affidavit is sufficient to make the will self-proved if the self-proving affidavit meets the form and content requirements under subchapter C, chapter 251. Again, I think there's a couple reasons for the provision, but part of it is we typically have signed copies now. It's not, before Xerox machines or before we were making as many copies where you might just have a copy of the will that's unsigned. We actually have signed copies, so it's more likely that the will was actually signed and was witnessed, and so the self-proving affidavit makes sense. I also think this provision was added because there's a conflict in some of the courts. Some of the courts, based on a case, they actually both use the same case for why a copy of a self-proving affidavit should be valid. But this tells us now, as long as it's a valid self-proving affidavit, the language is in substantial compliance with the statute, then the copy of the will can also be self-proving. Some more issues to look for. Probate of a will past 4 years. It says that you can't, first of all, you really are not supposed to be able to get an administration after 4 years. There are some slight, exceptions to that, but generally you're looking at muniment of title. You need to prove good cause, and this has changed by court over the years. It's gotten a little easier in some cases recently. Why did you wait 4 years? Why didn't you get it probated? A spouse, I thought everything was in my name. I thought everything transferred over. Then I found out there's one account that didn't, or there's one piece of property, or maybe the spouse didn't need to probate it. The spouse passes away, and now the kids find out, wait a minute, you never moved the house from dad's name to your name, and now we're stuck. So we need to probate it. And that has been found to be good cause. You're not the reason for the delay, somebody else was. In court two, at least, you will have an attorney ad litem appointed again to check on the unknown heirs, or I'm sorry, the heirs at law. So it'll be like a mini heirship again. And again, muniment of title is mainly what you're looking at. Disqualified executor. If your executor doesn't meet one of the criteria, then you may be dealing with looking at the successor executor, but you've got to have a reason for the executor, or they can sign an affidavit declining to serve. If the language doesn't say independent executor without bond, additional language that's helpful is there should be no action in the court. There's sort of some magic language that the courts want. It can't just say I appoint him as independent executor. Some courts will say that's not sufficient. Well, then will the heirs all agree to an independent? So it's the 3 kids and one of the kids is named executor, but it doesn't say independent. They can all consent to an independent administration. If there is a minor beneficiary, you will not get an independent administrator. The court is going to feel that they need to protect that minor. I'll say this, in Dallas County, I should say. Need to protect that minor. And so if I give it to Uncle John, and there's a 3-year-old, how am I going to know that Uncle John is taking care of that 3-year-old? Of course, if there had been the right language in the will, yes, Uncle John could have been an independent. But once it's not clear, the court will not allow for it to be an independent administration. You might have an issue with who are the heirs. If your will says, I leave my property to my children, then you may also want to include a declaratory judgment construing the will if you don't have an independent executor. If you have an independent executor, they can make that decision about who the children are. They hopefully know, and they can make that decision. If it's not independent, you may need to get a declaration. Letters of administration with will annexed. If you run through out of executors that are listed in the will, then you're applying for letters of administration with will annexed. It's just a key that there is a will here. This is not an administrator because it's intestacy. There's a will, but there's no named executor still to serve. You're going to have the same issue as above with the not having an independent executor. If there's minor beneficiaries, it's going to be a dependent. If all the heirs won't agree to this person, it's going to be a dependent. That's a whole other CLE and a lot more work. It's doable. just a lot more work and a lot more expense. So really benefits everybody if they can agree to independent as long as the person is trustworthy. If your will wasn't properly witnessed or notarized, it can be fatal depending on the facts of the case. If you have one witness, no notary, nothing else, you don't have a valid will. There are requirements that, you know, are actual requirements and will keep you from having a will. Is it ambiguous in any way? And if so, you may want or need a declaratory judgment. Can be a simple process, can be a bigger process, depending on what you're looking at. Kind of goes back to the beginning of knowing who the heirs at law are, or, you know, what kind of fight are you going to have? Is it a holographic will? All in the testator's handwriting. That will does not have to be witnessed, doesn't have to be notarized. Anyone can handwrite a will. I don't recommend it. But if you need to in a pinch, it can be done and you can probate a handwritten will. You're going to need a proof of the handwriting, an extra proof for someone who was familiar with their handwriting and their signature. Your posted citation, that approximately 1/3 are incorrect. That's from Judge Monroe who said that. So you need to look, so when you file your will, you order a posted citation and the clerks do it. You need to take a look at it. Does it contain the name of the testator exactly as on the will? Do you need to include an AKA? Does it contain the name of the executor exactly as on the will? You may need an AKA or FKA. You can also use formerly known as, and his advice was use this liberally. If it's close, you want to go ahead and use it. There's no reason, because you don't want to have your posted citation, get to court and they say, wait a minute, you're using a different name here. We got to start this process over and do a new posted citation, get a new hearing, etc. Better just to throw that in there and to check the posted citation that it was listed correctly. All right, enough of my talking. Let's watch another video. Oh, no, this one's on video. Sorry, it didn't pop up. Okay, here's an example of a will. Upon my death, I appoint my beloved wife, Penelope Ann Patton, as executor of my estate and bequeath to her 1/2 of my estate. That's the whole will. 2 witnesses, so that's great. That would have worked whether it was holographic or typed. Hopefully you see the issue. Only bequeathed 1/2 of his estate. We have another case with this right now and suspect that people may be thinking, I only own 1/2 and she owns 1/2 because it's community property, so I'm giving her my 1/2. But that's not what the language says. So that requires an heirship for the other 1/2. So probating the will take care of 1/2 of it. The other 1/2 will go according to an heirship determination, which is a different process. All right, here we have another self-proving affidavit. This was a case that I had and got a nice surprise from Judge Monroe when I got there, thinking I was good to go, and found out I wasn't, and I needed to have a few more proofs. You can take a look at it. I actually wanted to dispute one of the things he raised, but then I found another problem, so I decided I would not press anything and instead just get it fixed. So here are the problems. The one that I found afterwards was it's not actually sworn to by the witnesses. If you look at the certificate of acknowledgement, they acknowledged it. That is not sufficient for a will. I actually had to call this law firm in Nebraska and say, hey, you know, somebody may have been grabbing the wrong form for their wills and you may run into a problem with it. The affidavit doesn't say that the witnesses are above the age of 14. Whether that's substantial compliance or not, I don't know. Then Judge Monroe's problem was the blank. It said, we, Matthew Rich, and blank. It didn't say who the witness was. So there were some issues with this one. We knew it was witnessed. That wasn't the problem. He just said it wasn't self-proved. And so I needed to get I couldn't get a subscribing witness because this was in Nebraska. So someone who was familiar with the handwriting. Here's another will that we ran into some problems with. It kind of looks good as you're looking at it, but hopefully as you would look at it, you might see some issues. So I see that, it's signed. I see some witnesses. That looks fine. Clearly, I skipped some of the pages because they weren't pertinent here. Disposition of real property. If you go back, I leave it to my niece, Jane Smith, and to my sister, Sally Johnson. But then you look at the witness signatures and it's the same people. Again, having a beneficiary as a witness is not totally fatal, but there are some other requirements, and here it's a bigger problem. Beneficiaries or witnesses to will can be cured under certain circumstances. Look at 254.002. If one witness is disinterested, the other witness may provide testimony that corroborates. You also can use a notary as a witness. So if only one of the witnesses is a beneficiary under the will, but you haven't notarized, that notary can step in as a witness, but then you don't have a self-proving affidavit. So your notary, your will is just signed and witness. No notary required for that will. Self-proving affidavit has two witnesses and a notary. If your notary steps into position as a witness, you no longer have your self-proving affidavit. Here's a holographic will that we were able to probate. Again, I don't recommend them, but they can get probated. He went back and changed it. He listed things, but this entire thing was probated and the estate went forward. Here's Aretha Franklin's will. She had a whole bunch, but this is one of them. So even someone as famous and wealthy as Aretha Franklin may choose to do it this way. All right, this case, we'll start with the first video. Again, we're going to see an attorney involved. Just because an attorney does the will doesn't mean that everything's just hunky-dory and good to go. And I think you'll see here how the questioning again matters.
It says that you give $25,000 to Kathy.
Well, I can.
Is that what you want to do?
I can. If you've got that down there, I give her money almost every month right now when I get my checks. But I will.
Okay, so you want to give her, now you said before that you wanted to give her $25,000.
All right. If you put it down, I'll do it.
Okay. You also said, now, do you want to give her anything else? Is that all you want to give her is 25,000?
If I've got anything else to give her, I'll give it to her.
Okay. Also, Renee Guthrie.
It goes on. There's more.
He's not married.
Now,
He's just his youngest brother.
okay, now if Michael were to die before you, who would you want? Would you want it to go to his children or to go to Lee?
I'd want to go to Lee, wouldn't I? With,
I would say my children.
well,
Well, would you not want his children to receive it? When we talked before, you suggested to me that you wanted his children to receive.
you want me to say yes or no?
Well, kind of it's your decision totally. It's your decision totally.
If he would die before me,
Right.
I don't think that's gonna happen, so I'm not worrying about that.
The way we have it written here is that in the event that Michael dies before you, it will go to his children. Is that okay with you?
It's all right.
So again, hopefully you were shaking your head like I do when I see it. So many problems there. Beneficiaries in the room, the beneficiaries making the decisions. despite his proclamation that it's all her decision. The lawyer is asking leading questions. The lawyer's just trying to get her to go along with what he has in the document. So as a lawyer, you need to think about who are you really representing and helping there. But just know that even with a lawyer drafted will doesn't mean there's not any problems, which is why I had some of those questions at the beginning, looking at the date, looking at the signature, knowing who the family is and who the heirs at law are. After the will is probated, you have a few more steps. You need to do notice to creditors. That's simple, ordering that and paying for it. You need to do what's called 308 notices. You need to give notice to all of the beneficiaries in the will that the executor, that you've been appointed as executor, and give them a copy of the will. There are a few exceptions if they've already received their bequest, if it's a small amount, things like that. But if they have not appeared in the proceeding and they're a beneficiary, you need to give 308 notices. It's a qualified delivery method, hand delivery by courier, certified mail, return receipt requested, or an approved private delivery. You can get a waiver, which I highly recommend. Green cards are so difficult. If everybody's getting along, hopefully they'll sign a waiver. You know, you send an email, here's a waiver, here's the will, here's why I'm doing it this way. And if they'll sign the waiver, you can file those. And then you also do a certificate saying all these notices were given and how they were given. A benefit of immuniment is you don't have to do 308 notices. So that's one of the reasons I like immuniment of title. It just saves a step there. The 308 affidavit is signed saying that you gave those notices or got waivers, you know, whatever needed to be done. You also need to do an inventory and appraisement and list of claims. You list all the probate assets with their values. It can be approximate values. If you're dealing with real property, I use DCAD values. If you sell it, you know, quickly, then you might use that. But it's just giving the world an idea of what it's worth. You don't include non-probate assets. If your bank account went by pay on death or right of survivorship or it's in a trust, it does not have to go on the inventory and should not go on the inventory. Another recent change is September. In a typical inventory, you list, if they're married, you have to list whether it's community property or separate property. You no longer need to do that if the person wasn't married. You do need to break it down by real property and personal property. Real property in Texas is all that's listed. They could have $1 billion of land in Wisconsin or Wyoming, and you don't list it on the inventory. It's only Texas property. The list of claims is claims the estate has against others. It's not claims against the estate. You don't have to list the mortgage. You don't have to list any kind of loan that's out there, or line of equity line of credit or anything like that. It's if I have a claim, personal injury claim against somebody, the estate has a claim. That's what goes in your list of claims. And you can do an affidavit in lieu of inventory in appraisement. If you don't want this on file for the world to see, you have to give it to all the beneficiaries, and then you sign an affidavit saying, I've given an inventory to everybody, and I'm only filing this affidavit. Note that if you're pushing up against the deadline for the inventory, you need to file a motion to extend your time to file that. If you're late, you can no longer do an affidavit. You can only do the affidavit if you get it done either within the time for the inventory or you get an extension on the inventory. Then you can still do the affidavit. For immuniment of title, I told you file your order in the deed records, except for in the county where it was probated. That transfers property. Afterwards, you file what's called a report of compliance that basically says everything's been transferred. There's nothing else in the estate. You know, you've dealt with the bank accounts. You filed it in the deed records. You file your report of compliance. This can be waived by the court. Oftentimes it is not. I have on here, court 2 will waive only if the applicant is the sole beneficiary under the will. That could be true in all the courts. Typically, I've had to do a report of compliance, but every now and then they'll strike it. Muniment, no notice to creditors, no 308 notices, no inventory because you have no executor. So you don't have to do any of that. Again, another reason I like immuniment, it's a little easier and faster in appropriate circumstances. All right, so finally, a few few tips, maybe more than a few. There's a probate manual that the probate section has put out. I think a new one is coming out. It's through the probate trust and estate section of DBA. If you just search for it, you'll find it. Highly recommend this. These are court approved forms. I will say it's been a while since they've been updated, so you still need to check the websites, which is going to be another tip. Check the court websites and use the court staff if you can, especially with virtual and, since the pandemic. There's a lot more information on the court's websites, and it may tell you changes to documents or like the proof addendum that you can add in. The court staff can't give legal advice, obviously, but they may be able to tell you some things that you need to do. It's worth asking about a proof addendum or something like that if you can get through. Sometimes they're busy; they may not be able to get back to you. Here are the pertinent estate codes, Texas Estates Code statutes 256 to 258 and 301 to 310. Remember to use the proof for questioning. I see people all the time go in and basically reinvent the wheel, making up these questions or just very wordy or making it so their witness is talking a lot. These are simple probates for the most part. You can ask these direct questions. If you have multiple witnesses on a topic for some reason, you don't have to go through all 20 questions. You could say, did you hear my questions to so-and-so? Would your answers be substantially the same if I asked them of you? That is generally allowed if you're asking the same questions. A big question for some is whether to even probate the will or do an affidavit of heirship. I was not a fan of affidavits of heirship. I think it's always better to get a judgment from the court, but our courts are busy and backlogged, and it can take a while to get a hearing. And if your will has some little problems or just any question about it, an affidavit of heirship can transfer real property. It's not going to work for a bank account generally. It needs to be real property and simple. And if so, then it's worth considering now. I know a lot of lawyers who've said they'll do them all the time. Don't tell your client how long it's going to take. You have no idea, especially in Dallas. The courts are run a little bit differently, each of them. You don't know what problems you're going to run into. I highly recommend saying it could be 3 months, it could be 9 months. But I wouldn't make any promises to your client because they may be disappointed. Guides and checklists are online. You can find some Dallas attorneys who are very helpful and have a lot of information on their websites. If you run into a issue where a testator is partially intestate, or if you have a case where there's no will and you're doing an intestacy or a phone call, find a chart, use your chart. I've been doing this a long time. I always pull out my chart. The minute somebody says, okay, if a guy dies without a will and he has a wife and I'm reaching for my chart. Because you're going to forget some of those things, especially once you go up the chain to the parents and you're dealing with separate real property and separate personal property. Always use a chart. For virtual hearings, check the court for their requirements. They're putting a lot of information online. They're all different all over Texas, so check the website. Court 2 has started a couple years ago, I think, the 1-minute prove up. If you've truly got a simple will, everything checks out, you get your documents done, you can email the court before a hearing. I think it's a week before and say, I'd like to try for a 1-minute prove up, and they will get you approved. I had one in front of Judge Monroe when he was on the bench. I had one in front of Judge Troby, and then I had another one with Judge Monroe sitting in another court, and it was even faster than what they say on the Court 2 website. Judge Monroe swore in my witnesses and said something along the lines of, is everything in the proof true and correct? And they said yes, and we were done. It was amazing. Highly recommend. Know your court, be prepared, and prepare your client. The courts are different. They have different requirements. Be careful what you tell your client. Let them know it may take a couple tries to get a will probated. It's just complicated these days. So I would set up their expectations ahead of time. All right, one more video I have. Oh, I'm almost out of time. This is a case where the wife was visiting the husband in the hospital and brought some people to witness. And one of the witnesses started asking him some questions. She didn't like that. So she had been videotaping, or one of the witnesses had been videotaping him, and she asked them to leave, and he put the video camera down, but kept it running. I don't know if that was intentional. So here you'll hear what the wife had to say to the husband about signing the documents.
No,
You're really getting numbers things and
yes, it's his duty. Or we wouldn't be doing this.
that's what I understand. Now, this is not right and consistent.
Unless you don't know about what has happened. And that's what.
And neither does.
But it's none of your business. It's personal what has happened, what those girls have done in the past. It has, we are doing exactly what he wants done. And you have no idea what has gone on. And I had no idea that this would come up, that you would call Illinois, and then it says that you and I take everything that put in trust. And the advantage of the trust is, the advantage of the trust is business. See, if there's any money left, Michael gets it. Now, what they don't know is that this is your wish, but you told them the wrong thing out there. You told them that the girls are in this will, the girls aren't. Because you told me you didn't want the girls in here, because the girls have been, and mistreated you, and you've given them so much for you when they were alive. Remember that? Okay, when that attorney comes back and tell me that these, every time that I will say anything, that these are your wishes because of, that's the way you want it, because you have given those girls so much when they were alive. Will you do that? Okay, you see, but Michael and Susan get it, and your girls don't get it. Now, that's what this bitch man is complaining about, because he said girls have been left out. You see? And it's what you want, isn't it? That's what you said. You're not gonna back out on this, are you?
No.
Good, huh? And remember, Sharon gave me a heart attack. And remember how cruel they've been to me. She went to Shield and his wife, and told him all his lies. And all that awful stuff that you don't remember.
Your uncle left everything to charity. So far, we haven't been able to locate her. Perfect. All right, and that's the end. I'm sorry. I see it's 1 o'clock, so I didn't have time to get to any questions if there were any. My email is melinda@hartnettlawfirm.com. Happy for any of you to send me questions if you have any. And hopefully you learned some things from today and you get some simple probates that this will help with.
Thank you, Melinda. And just a quick housekeeping item, the MCLE course credit number is in the chat, but I will say that aloud as well. That is 174300523. Again, that is 174300523. Thank you everyone for attending today's session. We wish everyone a happy holiday season, and we will see you in January. Thank you, Melinda. Have a good day, rest of your day, everyone.
Bye.